There are good reasons for making sure that children are protected in proceedings before the family court. But as an investigative journalist, I can say with no doubt whatsoever that there are issues that should be being scrutinised by the media before the family court that aren't being, because of the confidentiality rules that exist. I can't enable identification of kids in family court proceedings. Most of the time that's a really good idea. But where children are hurt as a consequence of a bad family court decision, I think the public have the right to know that. And I think the public have the right to be able to test just how good a job the family court is doing. The problem is that unless I can personalise those stories and enable identification of kids and their families, I can't do that. And as a result, journalists are not scrutinising family court proceedings like they should be.
My name is Graham Archer. I'm a producer and journalist with Today Tonight, Channel 7 in Adelaide. The family court is a very difficult jurisdiction for journalists to report on. There are statutory suppression orders, which are there for good reason, in that they protect the identity of children and people's privacy, but they also act as a veil over the conduct and procedures of the court. Now, people under those circumstances are able to perjure themselves, they can issue false exhibits, and the fact is all human institutions fail, including our courts, and the only way to maintain the standard and quality is to keep them open to public scrutiny. I personally have been threatened on a number of occasions with jail if I reported on certain cases before the court, no matter how anonymous they were made. So this jurisdiction has become a more or less no-go zone for journalists, and a society that keeps secrets, a society that has institutions which aren't open to public scrutiny, is not a healthy place to be, and in this jurisdiction this must change.
The family court has operated under a veil of secrecy since it began in 1976. The idea was to protect divorcing couples and their children from the glare of publicity. All reporting of family court cases was banned, and no one was allowed into the court except the parties involved and their lawyers. But this came in direct conflict with the basic rule of law in our society, that all court hearings should be open for everyone to see that justice is properly carried out. As a result, the closed courts led to a feeling of suspicion and rumour about the dealings of the family court. The government was forced to change the law. It allowed visitors into the court, but it still banned reporting of cases with names. You could report the cases, but you couldn't identify the people. So the media rarely goes to the court. Names make news. Without names, people aren't interested in reading about anonymous people. It's important that the public should know what the court is doing, but this won't happen until the courts can be properly reported, complete with names.
One of the most difficult areas of court for us as journalists, especially in women's magazines where we're covering cases largely from mothers, the area that's the most difficult would have to be the family court. We're not allowed to cover the family court. We're not allowed to do interviews with people who have a family court involvement. And so from the moment we get calls from different mothers talking about really serious issues with very harrowing stories in the background, we are not allowed to cover those cases. We're not allowed to identify children who were involved. We're not allowed to identify mothers involved, not even when the children are dead. And so we get issues where we have mothers who've got children visiting or having access with violent ex-partners where it spells potential danger. And the stories are actually very chilling. And from the moment I hear them, I know that I'm not going to be able to report them. The magazines themselves wouldn't be able to run those stories. Their lawyers would certainly advise us strongly not to go there. If we are able to cover them, they can't be identified because that would lead to the identification of the children involved. And so in effect there's a blanket no reporting rule. And as a result of that, it's all bets off until children die, in which case it then becomes a court case if the father is still alive. If it's a murder-suicide and the children have been killed and dad has killed himself too, we still can't talk to mothers. What we would like is for a lifting or a relaxing of those rules, or at least an opportunity whereby our lawyers could go and argue on a case-to-case basis that whilst we understand there has to be strict confidentiality as a result of domestic wrangles, there are exceptions to the rule, and in those exceptions our lawyers should be able to argue that some of these stories are actually a matter of great public concern, and as a matter of public interest we should be able to report those stories.
Will keep us safe when we are thrown into the fire.